The automatic stay does not prevent criminal hearings from moving forward, but this also means that a criminal case based on writing bad checks could continue without violating the automatic stay. Although if the creditor's motive behind the criminal proceeding is simply to collect on a debt, that may be considered violation of the automatic stay. What about the bad check debt being discharged during bankruptcy? Bankruptcy Code Section 547 provides that a bankruptcy discharge does not relieve an individual debtor from any debt for money, property, services, or an extension, renewal, or refinancing of credit to the extent obtained by false pretenses, false representation, or actual means of fraud. Therefore, when an irate creditor comes to a bankruptcy court in a Chapter 7, 13, or 11 case where the creditor is holding the check issued by the debtor that was dishonored, the expectation may be that the debt is not dischargeable. Unfortunately, debt based on a bad check is not automatically and not even usually held to be non-dischargeable. The bankruptcy courts have split on whether delivery of a bad check constitutes a representation to pay. The majority of courts have held that issuing a bad check alone, without more evidence of misrepresentation or bad faith, does not constitute grounds to deny dischargeability. Another line of cases holds that the mere tendering of a bad check for goods and services constitutes or implies actual representation that the issuer has good funds to cover the check, and that if the check is bad, it should be a non-dischargeable debt on the basis of fraud and misrepresentation. To succeed in getting a bankruptcy court to find a bad check is non-dischargeable, the creditor has the burden of proof to show fraud or false representation by the debtor. What is fraudulent intent? The bankruptcy court will not look to state bad check statutes for guidance on what is evidence of fraudulent intent whenever a bad check is issued. The bankruptcy court will instead look at whether the issuance of the bad check constitutes a misrepresentation of a material fact or an intent to pay the amount of the check, and whether such representation is fraudulent. Factors that courts have looked at to determine whether a bad check should be dischargeable are 1. Whether there is an agreement between the parties to hold a post-dated check. 2. The time between delivery of the check and the bankruptcy filing. 3. Whether prior to delivery of the check, the issuer consulted an attorney about bankruptcy. 4. The number of bad checks. 5. The amount. 6. The debtor's financial condition at delivery of the check. 7. Whether multiple checks were delivered the same day. 8. Whether the debtor was employed at the time the check was written. 9. Whether the check was written on a closed account. 10. The debtor's financial sophistication. And 11. Whether luxuries or necessities were purchased.